okay? The purpose of today's hearing is I wanted to see if we would get service. I don't know what position the defense is going to take, and then to have a scheduling conference to determine how long do we need to engage in discovery. That is the exchange of documents and questions and requests for admissions, all of which have legal consequences if they are not responded to. And then how long before we would set this for a pretrial and a trial, as well as what type of alternative dispute resolution may be appropriate. So, Mr. Logreen, I'll start with you. Do you have any input for the court to consider on those issues?
At this point, I'm still looking into default, and that's all I'm concerned about right now. We filed default, and that's what we'd like to do.
Right.
A lot of this stuff I don't understand, and you refuse to explain it to me, so.
Sure. So, Mr. Logreen and Ms. Acker, I'm going to try and explain it to you one time, and I will never be explaining the law to you again. Am I very clear about that?
Thank you.
Well, it's not my job. In order for you to bring a lawsuit against somebody, you have to serve them with the documents. You can't move for a default before you have served them. You have not yet served the defendant, so you cannot move for a default until after they have failed to answer. They are under no legal obligation to answer until you have served them. So unless and until you serve them, you can never move for default. Now, Mr. Logering, is there anything else you would like me to know with regard to scheduling?
I don't know.
I would like to speak.
Okay, and in order to do this in an orderly fashion, I am going to address each party individually. So that's why I just finished with Mr. Logering. Ms. Acker, is there anything you would like to have the court be aware of with regard to scheduling?
I believe that the judicial system made error if they have filed 58 documents and it is not a clear case. It's not a case. You are saying that it's not actually a case because we have not filed correctly. Why wasn't this stopped at the very beginning with Judge Weiler? Why didn't a judge tell us that this was not serviced correctly and end the case and just dismiss it? Why did it go on for 4 months and many different motions? All of the motions were correct in that the 2 judges were recused. If it was not filed correctly, why were all the other motions going through as planned? Court has come back and forth with us, and so has the defendant. And they hired an attorney. They appointed an attorney that shows that they are represented. If you're represented in court, you have a case. I don't understand how it's not a case when there are 58, 59 documents on file by court. Could you explain that?
Yeah. Yes. I never said it wasn't a case. You filed a document with the court. No further action can usually take place until the other side is served. You have not complied with the rules of procedure regarding service. Some judges won't educate you on the law. That's why I am telling you I'm not going to educate you in the future. And so if you don't follow the rules, your case could be dismissed and you could end up owing the other side a ton of money for legal fees. So it's critical that you educate yourself with regard to the rules of civil procedure. I never said you don't have a case. And Court administration is not authorized to not accept your filings. Under the rules, they must accept your filings. So it doesn't matter if there were 10 documents filed, or 10,000 documents filed. That doesn't make any difference with regard to complying with the rules of civil procedure. Does that answer your question?
Yes. Thank you for explaining that.
Ms. Acker, is there anything else you would like me to know with regard to scheduling, which is the reason we are here today?
We have stated before that we are not scheduling any kinds of negotiations at this point. We are looking forward to the motion hearing and wondering if that is still on schedule for February.
The answer to your question is, it depends. You have not yet served the defendants. And so even if they have an attorney sitting at the other table, unless and until you comply with serving the defendant with the summons and complaint, the motion cannot go forward. But as of this date, December 21st, 2021, the dispositive motion is still scheduled to be heard February 22nd, 2023. In order for a dispositive motion to be heard, it must be scheduled 28 days in advance of the hearing with notice sent. So you have complied with that portion of the rule. However, under Rule 56, a motion for summary judgment, which is what you are essentially seeking because you have introduced evidence outside of the docket or the statements, and because if you properly serve them, I suspect that the sheriff is going to file an answer, then it would not be a default hearing, it would be a motion for summary judgment. Does that answer your question?
Yes.
And I'm trying not to get snarky with you, Ms. Acker, but I'm trying to get you to see, I think you may be in over your head without an attorney. And so, again,
whatever.
Wait a minute, wait a minute. For the record, Ms. Acker just snickered, and for the record, Mr. Lubbering just said, whatever. What else would you like me to know?
For the record, I would like
The snarkiness on there too.
I would like the record to know that we have complied with all of the other rules that we are supposed to. I do not appreciate saying that we are over our heads. That is implying that an indigent, a person, an average citizen cannot sue somebody, the government, in court. And we have the right, by our amendments, to redress government when there is wrong that is done to us. Excuse our attitude. We were stomped on by the police department.
Strangled, beaten, had guns pointed at us.
You can't both speak at the same time.
Okay, we are strangled, chokehold. We are not happy about being here. We feel that we have tried to do everything to get our paperwork in correctly, and we keep getting jostled around and told this isn't right, this isn't right, this isn't right. But what happened at the very beginning was not correct. So we're just asserting our rights. We are not in over our heads. We will take this on whatever it takes, or we will get a courtroom of people behind us to help us take this on, because we have to stand up for what is right in this world. It is not okay, just because they're police officers, to harm us while we are in their custody. So
Ms. Acker, my response to you would be, first of all, I'm not judging anything about you being indigent or not. I know nothing about your financial circumstances. So where you are getting an impression that I am judging you based upon indigency, I do not understand. Secondly, I think that people spend hundreds of thousands of dollars going to law school for a reason. They understand that there are rules of procedure, rules of evidence on how to conduct hearings and how to conduct what happens in a courtroom. I think all of those